God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to an oral argument session here at the 5th District Court of Appeal. As the marshal indicated, I'm John Harris. I'm the judge presiding this morning, joined on the panel by Judge Rand Wallace and Judge Meredith Sasso. Two cases on the docket today. In each case, each side will be given 20 minutes. Appellant can choose to reserve as much of that as you would like for rebuttal. Default will be set at 5 minutes, but if you'd like anything other than that, please just let me know. Please also keep in mind the arguments today are being live streamed on YouTube. If you have, and this includes anybody in the audience, any electronic devices or noise-making devices, please go ahead and turn those off or silence them at this time. First case we're going to have this morning is case 21-1981, Joshua Ramsamy versus State of Florida. Mr. Pennell, if you are ready, you may proceed, sir.
Thank you, Judge.
Are you okay with the 5 minutes for rebuttal?
5 minutes works for me, thank you. May it please the court, my name is William Pennell and I represent Mr. Josh Ramsamy, the appellant in this case. I believe there's a couple important facts the court should consider when making its determination in this case. One, in opening statement, the state acknowledges that this was a circumstantial evidence case with no eyewitnesses, no DNA or video evidence, and no evidence directly linking the defendant to the shooting. Secondly, the state acknowledges that the case is based primarily on the testimony of the defendant's wife, Rachel Bassoon, and during closing argument, the prosecutor, not the defense, describes Ms. Bassoon as, quote, a liar, a thief, a crook, self-centered, and a person exhibiting no remorse. As noted in our briefs, the trial court committed 6 separate errors in this case. It's our position both individually and cumulatively those errors deprived the defendant of a fair trial, and we'd ask the court to reverse. Because we have limited time, I'm going to focus my arguments on issues 1, 2, and 4. Certainly answer any questions the court has about the other issues. Initially, it's our position that the trial court abused its discretion by either not granting a mistrial or not granting individual voir dire after it was disclosed to the court and to the jury that one of the jurors' wives and then that juror tested positive for COVID-19.
Can you just, as an initial matter, discuss the preservation issue on this? I see that the initial motion for mistrial was after the positive COVID test result, but there didn't seem to be a basis for the mistrial. Then there seems to be a second motion for a mistrial that is because the court discussed issues outside of the presence of counsel, and then a renewed motion at some point. Was the specific argument that, and maybe I should let you begin by, with those kind of basis in mind, can you explain the specific argument that you're making on appeal and whether or not that was preserved, and if so, where?
Sure, I think the place where it was preserved is on page 1170. Okay. This is after the court and the parties discussed the fact that 2 of the 4 individuals that got a COVID test would not disclose what the results of that test were. And in light of that, the defense lawyer at trial asked for a mistrial because of the exposure to the other jurors and because of the potential harm to other people, or the potential fear of the other people on the jury not knowing whether these people tested positive. So I think, given all the previous conversation and previous discussion and the specific language used by the trial lawyer on page 1170, it's clear in the context of the argument that the defense lawyer is arguing that these jurors are going to be worried about getting COVID and not paying attention to the trial. And that's our argument on appeal, is that the defendant had a right to a juror that was fully attentive on the case, the facts and the evidence, not a panel of jurors that are worried about whether they're going to get sick, whether they're going to get their family sick. And the court itself, the trial court itself, in the beginning of the case, when the first disclosure was made, acknowledged the problem that existed and said, quote, and this is when she says, I'm not going to tell the jurors that we have a positive test yet or that the wife is positive. He says, I don't want them to be in a position where they're worried about their own selves and not focusing on the evidence. And then we'll be talking potentially about a mistrial. I'm afraid of creating more fear than I need to at this point, and this is at 11:30 of the transcript. The problem is then when defense counsel asks for a mistrial and asks for individual voir dire, the court is unwilling to address the concerns that she initially recognized. And we acknowledge that this is an issue of first impression, and this is difficult for the trial judge to deal with, but I think the trial lawyer gave her the tools she needed to do it, and she just didn't take those tools and resisted the request for the individual voir dire and for the mistrial.
So why is this not enough? And I mean, this kind of is both, but where the court, says, is there anybody who feels uncomfortable? Anybody? If you can't sit here and pay close attention, which really tracks the language of the argument that you're making on appeal, is there anybody by a show of hands? And then, there's the confirmation in the record that there's no show of hands. And then almost a second opportunity when the jurors go back and they're instructed that they can write down whatever concerns they have. Why is that when we're looking from an abuse of discretion standard? Why must it be an individual questioning of each juror?
Well, we know from the decisions in Mendez and Dippolito that jurors are more likely to give honest answers when they have individual voir dire and they're not asked to raise their hand in a group setting. Those cases establish that fact. I think that's even more apparent in a situation where we're talking about private medical issues and private medical concerns. And as the court is aware, COVID-19 has been politicized, so people may be uncomfortable discussing their views on vaccines, on the seriousness of the virus in a group setting. But we have the two cases.
Mr. Pinnell, aren't you asking a judge in really an unprecedented time dealing with this virus, and there's pressure on the courts to get cases moving, there's speedy trial issues, speedy trial considerations, and you're asking a judge to basically act in a vacuum without any discretion. The judge who is there with the jury, who sits through the jury selection, who sits through the voir dire, who conducts voir dire, and then you're saying the judge needs to exercise all the tools in order to ensure a fair trial. Is that what you're saying? Basically, check your discretion at the door, and you should have, in this case, there should be a hardline rule in dealing with COVID that you ask questions of every juror individually. Is that what you're saying?
It's not what I'm saying. I don't think there's a hardline rule, and I don't think that was required in the voir dire before the trial started. But when in the middle of a murder trial where a defendant is facing life in prison, mandatory life in prison, where there's a disclosure during the height of COVID that one of the jurors is positive, it seems reasonable to me that individual voir dire would be appropriate. And I would agree with Judge Sasso's question and statement that the judge acted within her discretion had there been no notes following the answer when she asked him if everybody was comfortable moving forward. But we had a note from a juror who specifically indicated that the juror was worried about jurors having contact with people that had COVID and wanted those jurors to alert the court before they arrived. And We had two jurors.
Doesn't that note, though, I mean, the way it's worded, it seems like the juror's just giving the judge some advice. Like, it would be prudent to recommend that jurors who are exposed to COVID report this information to the court prior to arriving. But how do we discern any sort of concern, or that that juror couldn't sit?
Well, the juror obviously felt strongly enough about it to write the note. The juror, I think the content of the note itself establishes that the juror is worried about individuals showing up that have had contact. So I think that's evidence that we have at least one juror whose mind is not totally on the case, but is being distracted by this COVID issue. We also have two jurors who will not disclose the results of their test to the court, so we know they're at least concerned about their privacy or have some concerns about medical issues. So it's our position that, and then there's two.
Did the jurors forfeit their right to privacy when they served on the jury with regard to their medical situation, their medical condition?
They don't, and we're not arguing that. The question is whether the court abused its discretion by not granting individual voir dire, and it's our position that under these circumstances, which I agree are difficult for the trial judge to navigate, but she was given the tools to do it and chose not to use them.
What did the judge do in response to that note?
All she said is, I'm going to pass that along. She never said that she did nothing in response. She said she was going to pass.
She moved the trial to a bigger courtroom where the jurors could be more spread out. Was that prior to the note, do you recall, or after the note?
I don't know for sure. I don't believe it was in direct response to the note. She certainly did move the courtroom to the case to a bigger courtroom. I agree with that, and that certainly was appropriate and a well-intentioned move and the appropriate move under the circumstances. This is a difficult circumstance. I think the judge did a good job. Mostly, I think that she just missed the boat when she did not grant the individual voir dire when this difficult but important issue arose during the trial.
What was the configuration of the courtroom for purposes of the trial when it was moved to the 23rd floor of the Orange County Courthouse?
I believe the jurors were spaced and there was appropriate social distancing.
Okay. So in that courtroom, there's a huge jury box, correct?
There is, Your Honor.
Okay. Were the jurors confined to the jury box, or were they allowed to spread out all over the courtroom?
I'm not 100% sure, but I believe they were able to spread out.
Okay. So there's quite a big seating gallery behind the bar in that courtroom, and then there's also a second level, right? There's a balcony in that courtroom as well.
To be honest with you, Your Honor, I've never been in the courtroom. That's what I understand.
Okay.
But
was any of that in evidence, though, as far as how
No,
the
not
trial
that
was
I'm aware of.
conducted? Were any of the jurors, did they express concern about their safety after this exchange with the court?
well, I think that the one note from the one juror is evidence of concern about safety.
Did any of the jurors indicate that they could not focus on the trial in light of the disclosure of the COVID test results?
They did not. I think the issue is that trial counsel should have been able to explore that issue further in this unique circumstances and was precluded from doing so. All we had was the group question, which the case law indicates is not always a sufficient way to deal with it because jurors are reluctant to answer questions like that in a group or to raise their hand. Additionally, it's our position that the trial court erred by permitting the defendant's wife to provide testimony about statements he made to her in violation of the marital privilege. The court overruled that objection based on its conclusion that the objection or the privilege had been waived by the prior introduction of statements during the defendant's interrogation. It's our position that the Florida Supreme case law clearly indicates that even if there was a waiver, and we'd argue there was not a waiver because those statements were introduced for purposes of interrogation and for purpose not for substantive purposes, but to show the jurors how Mr. Ramsamy reacted to the interrogation techniques used by the officers.
Is that based on something in the record?
I'm
Or
sorry?
was that discussed in the record?
It
before
was.
amended?
Trial counsel argued it, and trial counsel on cross-examination of the officer talked about interrogation techniques. But even so, both the Boland case and the Taylor case from the Florida Supreme Court clearly indicate if a defendant initially waives the spousal privilege, the waiver is revoked by a subsequent objection.
So let's start with Bolin. Bolin, there's a statement in Bolin that there was no privileged information elicited as a consequence of the letter, which had served as the basis of the waiver. Arguably, this case is different in that respect. I understand your argument, but let's take for the moment that it was waived at some point. If there is this kind of cat out of the bag aspect to this, why isn't this more like Waddell, where the court said that the defendant had already waived it, and waiting 2 days after the prosecutor commented on it before moving for a mistrial was too late? So,
Go ahead.
yeah.
Well, it's not like Waddell, because Waddell, he waited 2 days before raising any objection, and there's no evidence in Waddell that additional testimony was provided in violation of the privilege after the objection. So really, all Waddell stands for is you need a contemporaneous objection, and you can't wait 2 days just to move for a mistrial whenever you never make a contemporaneous objection. There's no subsequent testimony after the objection is raised and the waiver was revoked. What we have is more like the Taylor case, where there was at least one question that was asked and answered where privileged information was revealed, and then the objection was raised, and the court said, well, the original information is admissible, but any subsequent statements could not be admitted. So
And do you think that the fact that in Taylor it was the state that opened the door to that testimony, do you think that's a material distinguishing aspect?
The state opened the door to the testimony in this case. They presented the video, not the interrogation video, not Mr. Ramsamy. So I think it's directly on point. I'll reserve the rest of my time for rebuttal. Thank you.
Good morning. May it please the court, my name is Deborah Chance on behalf of the state. The defendant was not entitled to a mistrial here after one of the jurors tested positive for COVID. The court did not abuse its discretion in denying the request for individualized voir dire. A mistrial would have been too drastic, and it's only supposed to be used when the error is so prejudicial as to vitiate the entire trial. Here, the COVID issue didn't even come up until they were about 2/3 of the way through trial. I think the court here went above and beyond to make sure that it didn't affect the trial. As you all noted, they moved the courtroom to courtroom 23, which was a much bigger courtroom. The court even arranged for the jurors to get multiple tests if they wanted them. The court reminded the jurors that the courtroom was sanitized multiple times a day. The courtroom was fogged at night. And of course, juror 279 was excused so that there was no risk of further exposure from that juror. I think asking the jurors as a group whether any of them felt like they couldn't focus on the evidence was more than sufficient. Not a single juror raised their hand. And the court was in a superior vantage point. She was able to look at the jurors' faces, judge their reactions, and determine whether a mistrial was necessary or whether any of them truly had concerns. As to the point of the individualized voir dire, my argument is if this truly was such a politicized issue and was an issue that the jurors felt uncomfortable speaking about, I think the remedy of allowing the jurors to go back in the jury room and write individual notes that would be passed along to the judge is actually a better option, because I think if they truly felt uncomfortable, they'd be more likely to be forthcoming writing the notes as opposed to the individualized voir dire in the courtroom where all eyes were on them. So I think this was actually a better resolution if they truly were uncomfortable speaking about it. Moving to the marital privilege issue, I don't think the trial court abused its discretion in this case. The privilege was waived. It was not asserted by a proper objection. The privilege could have been asserted at any time prior to trial via motion in limine, but it wasn't. By the time it was raised, they were well into trial, and by that time the jurors had already heard a wealth of evidence about a ton of the marital communications. Specifically, during the defendant's interview with police, the police stated to him at least 4 times that his wife was telling the police that the defendant admitted to them that he killed these victims. And then also during that same interview, the defendant discussed a lot of marital communications with the police, the most notable of which was his admission that he and his wife decided to hire someone to kill the victims. And then, of course, during Amelia Bassoon's testimony, she discussed a lot of the marital communications as well, including their
You
decision.
briefed that if it was error to allow this, it was harmless. Why would it be harmless? I mean, under Taylor, doesn't it, we look at the substance of the communications, and basically a confession is not going to be harmless?
Well, I think that in those cases, they didn't have as much of a waiver as we have here. Because this is just there's so much evidence of a waiver prior to this objection being placed on the record. I think that's different. There wasn't as much of a waiver in those cases. I would also point to the Woodall case, because in that case, the defendant, as he was being arrested, said to his wife, he whispered in her ear, he was being arrested for murder. He whispered in her ear, "Find the knife, it's behind the dresser, get rid of it." That's not an outright confession, but it's about as close as you can get. And that was still considered harmless in that case.
And I mean, to the extent that there was not additional testimony, it was somebody just truly sitting on the privilege before it was asserted. How would you distinguish then Bolin and Taylor from this case? I mean, what would your response be to example for the argument that because the state introduced the evidence of the interrogation, that it was a waiver that could be revoked and then reasserted?
Well, in Bolin, they specifically dealt with the issue of explaining that once the horse is out of the barn, it's out of the barn, you can't unring the bell. In Bolin, in a letter, it seemed like he was waiving his privilege in the letter, but as a result of the letter, they still hadn't actually elicited any testimony from the wife. Nothing was actually gained as a result of that letter that was considered a waiver. In this case, we've already got the defendant's interview with police, where they state that he admitted to her that he killed the victims. He admitted that he hired someone to kill them. She had already testified that they decided to rob the victim of the $50,000. And I think that was sufficient. There was no objections made at any time. They discussed multiple redactions prior to trial. This was never brought up. So I think that is the defining characteristic that distinguishes them in this case. I think it was harmless, even if it was error. The wife was still allowed to testify as to her observations of the defendant's criminal actions regarding this crime. She testified that he left the house the night before the murders with the gun. He didn't return until the next day. When he did return, he took off all of his clothes and put them in a bag. He put the gun in the bag too. He then showered. She then observed him cutting up the gun with a grinder. And a neighbor identified the defendant as the man she saw at the victim's home and his car just mere hours before the victims were killed in this case. The defendant turned off his phone so he couldn't be tracked. And again, his own statement to police as well had already admitted that they had hired someone to kill these victims as well. Given all that evidence, I think that even if it was error to admit it, it was harmless error. If your honors have no further questions, I'll rely on the arguments in my brief.
Okay, thank you. Now, just under 4.5 minutes.
Thank you, Judge. May it please the court. The state has cited and has provided no explanation for why it was inappropriate for any waiver to be revoked. They don't distinguish or explain why Taylor would not control over Woodall. The facts of this case are more analogous to Taylor than Woodall. There's no requirement that an objection on marital privilege be made prior to trial. The evidence that was introduced during the interrogation is different in kind and content than was introduced through the direct testimony of Amelia Bassoon. When you hear the officers questioning the defendant, they simply say, "Your wife says you admitted this." When Ms. Bassoon testifies, she gives a detailed explanation of a confession, that includes details about how the alleged shootings of each victim occurred, and talks about statements that she attributes to the defendant would show some effort to conceal the crime by asking for a bag to put the gun and his clothes into. So the statements are different in kind and certainly way more prejudicial than the statements introduced during the interrogation. The court is correct that under Taylor, the state cannot meet its heavy burden to show that the error in admitting this testimony was harmless. The Taylor case points out that the Florida Supreme Court has previously found the improper admission of these statements to be inadmissible and reversible error in 2 first-degree murder cases where the statements involve confessions. And in Taylor, they find it to be harmless because it does not involve a confession. But they point to the Bolin and the Kuhn case where 2 first-degree murder cases were reversed. Our case is more analogous to the facts of Bolin and Kuhn than it is to the Taylor case on that issue, on the harmless error issue. It's our position the state cannot meet its burden to show beyond a reasonable doubt that Ms. Bazoon's testimony that was improperly admitted did not contribute to the verdict. Certainly there was testimony or an admission about Mr. Ramsaway making some admission to soliciting an individual to kill the victims. He's not charged with solicitation to commit murder. He's charged with actually pulling the trigger. That's the state's theory of defense. So it's our position that does not make the error harmless. That statement in no way establishes that he was the shooter in this case. And that is the state's sole theory of prosecution in this case, that he actually shot both individuals. I think it's impossible for this court to conclude that the error is harmless under these circumstances, given the detailed testimony Ms. Bazoon was permitted to provide. Finally, the state's argument that there was no prejudice because the trial was almost over regarding the COVID issue. There was 3 days of the trial left. The defendant hadn't testified yet, and closing argument hadn't yet occurred. To suggest that those important parts of the case are not important and we did not need the jurors to be 100% focused on those parts of the trial doesn't hold water. We'd ask for the court to reverse Mr. Ramsaway's convictions for the reasons we've discussed today and all the reasons I've discussed in the briefs. Thank you.
Thank you.